Right, abusuan mo bibia kwa ban fambra 2K nis and blossom o YouTube so ase abusuan for yaba as usual. Ensem ahodo a ekoso e Ghana ase ne de beso mahwefo. Ene atiefo nya na abusuan no kasa no. Encha ekra na chese ebeto odwa se eye justice tokono. Chese ye pam no e de na free e ni dibreso apeni pafoforo e de na ba be hye na nan. Na abusuan ensem e na momfremam ensem a ye tete ne se eye ade ase chachuchu kata. Abusuan ane ono na e likely say ye be appoint no as the next chief justice ewo omem hasi na abusuan nsem ni nyina enchiremu ewo hasi mempesem kasabet ntebeko nya kwa akwaje wa abra chese evidence ahodo enso etasa ensem weto ede abayeba ba betina se ne de ho enkomo mesrew se wonya subscribe from my YouTube channel ya na wa subscribe dem na bibia so etimi aye kama medin ede kwam gentle
dismiss the judges whether he could do that or not. So by 79, when we're putting the 79 Constitution together, we started bringing certain forward-looking provisions to safeguard the independence of the judiciary particularly. And so you will notice that in 79, after Liman had won, and knowing the role that Chief Justice Apalu played relative to the commissions of inquiry involving Nkrumah's appointee, the view was that the pro-Liman elements in Parliament felt that it was an opportune time to deal with Chief Justice Apalu with the creation of the Supreme Court. And therefore, if Chief Justice Apalu had gone through the parliamentary vetting process, he would have lost it. And hence, the lecturer then in KNUST, Dr. Amwakutufo, then brought to for an attorney general. That constitutional history has shaped what we have now in Article 146 to just provide a check with what has happened previously so that going forward, we'll know what to do. Then came Frank Ajay-Chum. If you recall, my senior Bright Akwete had brought a petition for the removal of Chief Justice Akwa. But strangely, that petition found expression in newspapers in terms of content, right? So President Kufuor had received the petition, but the petition was out there in the various newspapers, including the content. So what happened? Frank Ajay-Chum then goes to the Supreme Court. He said, no. There's an in-camera provision. The word in camera, the Latin phrase simply means in chambers. It allows a certain level of privacy in the whole chain. It does not admit of any other thing. Well, the Supreme Court had departed one way or the other from the legal consequence if the petition even comes out. Does it void the petition? What becomes of the petition? Because in the case of Madame Charlotte Osei, we had gotten the benefit of seeing the entire petition, even before the prima facie determination was made. But nonetheless, the process proceeded until she was removed. But you see, there's a curious development. What development is that? We are being told that the Chief Justice, as it were, has a right to be heard. Right? And like my learned senior pointed out, that is not borne out by the express provision of the Constitution.
Yes.
And so if you look in Frank Ajay-Chum, the Supreme Court basically just said such committees should find a way of bringing proceedings to regulate its activity. So in the specific case of Charlotte Osei, if you recall vividly, Madame Charlotte Osei, acting through her lawyers, had written to President Nana Addo Dankwa Akufo-Addo that, Mr. President, having gotten receipt of this petition for my removal, I need to have the benefit of knowing who and the nature of allegations being made against me. Fair point. Now listen to Mr. Eugene Ahe's response to Madame Charlotte Osei. He said, I find your response or request extremely curious. This is not the proper forum for you to be asking for copies of the petition against you. This is President Akufo-Addo, a lawyer. His executive,
human rights lawyer.
I beg you. His executive assistant, a lawyer. His deputy attorney general, now Godfrey Dame, a lawyer. Attorney General Gloria Kufu, a lawyer. All of them together informed the then presidential Gongon Bita, Mr. Eugene Ahe, that it was not in the place of Madame Charlotte Osei to be making a request for the petition at this level. And that, listen, when it gets to the Chief Justice, because remember that the process is bifurcated. There's one for Superior Court judges, and there's a separate provision when it comes to the Chief Justice. Yes. Because of the special role that she plays as the head of one co-equal arm of government. So the Constitution and its framers say, listen, when it comes to all those other persons, including the heads of independent constitutional bodies, what do? Let the Chief Justice be the one making the prima facie determination. In this case, that it involved the Chief Justice herself. She cannot be sitting on her own matter, making a determination whether the allegation against her meets a certain threshold called the prima facie. So what happens? He said, in that case, the president shall mandatory consult with the Council of State. Mandatory, no discretion.
Yes.
Question, who then makes the prima facie determination? If you recall, in the specific case of Charlotte Osei, what we were told is that the president was just a conveyor belt, a conduit for transmission, yes, without more. That is what we were told.
Yes.
What has changed? Incidentally, Godfrey Dame, a lawyer now, was a deputy attorney general then and supervised that process. You see, I have always maintained that because we are building a constitutional democracy that should last the next 200 years and beyond, we need to be very careful of the precedent that we set. When this issue of CJ came up, I reached out to some leading MPP lawyers, senior lawyers. I said, look, you all sat down for Akufo-Addo to destroy this country. You all sat down. And this, my friend, said, if Akufo-Addo did the wrong thing, why should John Mahama follow? I said, what in God's name makes you think that Akufo-Addo deserves the right to be wrong, but John Mahama cannot be wrong? What makes you guys think that for some reason you are better placed to do whatever pleases you and nobody can do the same? I think that our friends in the NPP must appreciate, and like I always use the word, and maybe you see, you are just asking yourself that there's no, you see, it is not only in the house of NPP that they are madmen.
But you see,
every house there can be a Mensa. Yes. Is that not the case?
Yes, exactly.
So you see, at that time, it was convenient to do everything because the entire NPP and Nana Addo Dankwa Akufo-Addo, the Vice Dr. Mahmoud Bawumia, the Attorney General and the Deputy, the entire NPP spectrum were determined to get Charlotte Osei out. And so it didn't matter the question of fairness and reasonableness. And so we got to the point where the only time Mrs. Charlotte Osei got the benefit of getting a copy of the petition was when she appeared before the Justice Bene committee. And listen, it was Justice Bene, her ladyship Agnes Doji, and the late Justice Mafosa, Abrampa, and one other woman. 5. It was when she appeared that they formally gave her a copy. In fact, the first day, what they said was that they are coming to determine the rules to govern the committee and its work. That was there. What has changed? When President Mahama received the 3 petitions, beyond forwarding it, has he taken any other action? No.
Well, but if you look at Vincent Assefua's reliefs, and I go back there because this is one of 2 cases challenging what the president has done in forwarding these petitions to the Council of State. He says that one of the reliefs he's seeking is a declaration that upon a true and proper interpretation of Article 146 and 296, he doesn't just dwell on 146. He brings in 296 of the Constitution. The president is mandated to notify the Chief Justice about a petition for the removal and solicit comments. The reason why he brings in 296, and I'm sure that you can quite understand, because 146, as we've said here, does not explicitly, respectfully. Let me finish with the point.
So that,
does not very explicitly state the timeline for the timeline for. You don't want to use your thought on it.
Article 146, 8, from 6, 7, and 8 says the president shall. That's clear. The president shall. Article 296 relates to discretion.
Precisely.
Where the Constitution, assuming the Constitution has said the president may consult the council, then you can now introduce the issue of Article 296, where it prefaces that where discretionary power is conferred on the person, that person has a responsibility to act not capriciously, must be fair, should not be whimsical. In this case, the operative word there is shall consult the Council of State. Having so forwarded the 3 petitions to the Council of State, has President Mahama taken any other step against her ladyship, the Chief Justice? No.
Well, I directly make reference, and I'm coming to the point. I directly make reference to the second relief. That would answer the question that you're asking. Because he says, and this is the relief sought by Vincent Asifua, that the failure by the